So today you're going to hear some of the most renowned people that have written and spoke about the doctrine of discoveries and its impact on indigenous peoples, not only in this country, but throughout the Western Hemisphere. So with that, I'd like to introduce to you Mr. Professor Robert Miller. He is from the Lewis and Clark University, and he's going to share with us his teachings and his wisdom about the history of the doctrine of discovery. Professor?
Thank you very much. I want to thank Tupac and Shannon and everyone that was involved with inviting me to be here, and I'm delighted to get to speak with you on this topic. I am a citizen of the Eastern Shawnee Tribe of Oklahoma, and I'm the Chief Justice of the Court of Appeals of the Grand Ronde Tribe in Oregon, and I'm also a judge for other tribes in the Pacific Northwest. I have been studying this topic for quite a few years now, and I'm delighted to be here and to talk with you about the doctrine of discovery. And as the title of the presentation today, the whole program, is the impact of the doctrine of discovery. And so I think I have a half an hour to talk to you about 500 years of history and law, so I'm going to talk really fast. First slide, please. We're going to take a look at this map today, and we're going to talk about manifest destiny. That's my assignment today, and that's what I wrote about in my 2006 book. And I described how the doctrine of discovery became manifest destiny. This American idea of what? I think most Americans know the phrase manifest destiny, but if you ask them to define it, they would not be able to. So that's what we're going to talk about, and we're going to come back and forth to this map several times, because every one of those colored areas and the growth of the United States is explained by the principles, the elements of the doctrine of discovery. And my argument is that the United States adopted this international law of discovery that we're going to talk about and turned it into what we call today American manifest destiny. So we will come back and forth to that slide. Obviously, I live in the Oregon country, so we'll be talking about that. We're here now in this New Spain, what later became Mexico, and then what the United States acquired after the Mexican-American War. Next slide, please. So I'm going to very briefly describe the doctrine of discovery. Later, Steve Newcomb is obviously going to explain to us the European backgrounds and the definition of, the meaning of the doctrine of discovery and how it grows from ideas of domination. But I need to explain to you very briefly what the doctrine is, and then break it down into the 10 elements that I define describes the doctrine of discovery, and then we'll talk about how that became American manifest destiny. So in 1823, the first United States Supreme Court case to address Indian law issues was literally about what title, what ownership did tribes have of their lands. And this case was about what is now tribes in the area of Illinois and Indiana. It was, in fact, the Illinois tribe and the Piankashaw tribes, and it was their lands that were at question in this case. Of course, the tribe was not involved in the case. The tribes didn't have a lawyer in the case. These were two Americans arguing over lands that belonged to tribes. And here is what the United States Supreme Court ultimately held. This country, this court says, was founded and settled on the doctrine of discovery and of conquest. And I'll explain that in a little bit. But when Europeans walked ashore with their flag and their cross, folks, and stuck it in the sand, when Meriwether Lewis crossed the continent in 1803 to 1806 and carried a branding iron. I was at the Oregon Historical Society 2 days ago, and they had the original Meriwether Lewis branding iron. And as he crossed the country, once they crossed the Rockies, Meriwether Lewis starts branding his name. It says U.S.CAPT, because he was a captain in the Army, M.Lewis. And they start carving their names on trees and sandstone cliffs, and Lewis starts branding his name. Gee, it sounds like he was sticking his flag and cross in the soil, doesn't it? He was claiming the Oregon country for the United States, plainly, and using principles that Johnson v. McIntosh reaffirmed in 1823. So next slide. What did it mean when European countries showed up with their flag and cross? What allegedly happened to native peoples? Well, here's what the court said. Native peoples immediately lost some of their property rights. They no longer were considered the fee simple absolute owner, which is an Anglo-American property law principle. When you and I buy our homes, we're the fee simple absolute owner. But this court said that by the magic of Europeans showing up, or Meriwether Lewis out in my area branding trees, tribal governments somehow, crazily, lost their full ownership and rights in their lands. What else did they lose? Well, the court says they also lost some of their sovereign powers. They lost their international powers because indigenous nations were no longer supposed to trade internationally or engage in international diplomacy. They were now only supposed to deal with that European country that discovered them. How ironic that is, folks. As you know, Meriwether Lewis and William Clark, they were lost everywhere they went. Every Indian person they ran into, they said, "Where are we and what's up the road?" But oh no, we, American history, characterized that the natives were discovered. How ludicrous. But that is what we're dealing with. We have to understand the law of the United States, the federal Indian law of the United States, to understand the impact then of the doctrine of discovery on us today as Native peoples and on our governments. Let's see, so next slide. One more. So I break the doctrine of discovery down into 10 elements, and the pages, thank you very much, are handing out 2 handouts I brought. I obviously didn't bring enough, so I think they're making some copies. But I give you the elements that I think comprise the doctrine of discovery. How did Europeans make a legal claim under international law, under the papal bulls that Steve will talk to you later from 1436, 1452, 1455, that divided the world for Spain and Portugal? Wow. I guess I wish I'd have been Spanish or Portuguese back then when the Pope divided the world for just those 2 countries. But here's the elements that I argue make up the doctrine of discovery and how a European country, and later the United States, made claims over native peoples. 1, you had to be the first European or American to show up. So how'd you prove that? Gosh, maybe that's why Meriwether Lewis carried a branding iron with him. How else did Europeans show where they had showed up first? Well, they mapped the areas. They named rivers, mountains, and various features. Remember what Lewis and Clark did? They named every single river they encountered. Gee, what's that Pike's Peak that's in Colorado? Do you know who Pike is? That's Lieutenant Zebulon Pike that was sent by Thomas Jefferson in 1805 to explore the parameters, the limits of the boundaries of the Louisiana Territory. Go back to the map, please. Look at the territory of what we call the Louisiana Territory, folks, and look at the Oregon country. Have you ever pondered what makes those boundaries? Well, the boundaries are the drainage systems of those major rivers. The Mississippi River, the drainage system, comprises the territorial boundaries of the Louisiana Territory. In 1804, after concluding the Louisiana Purchase, Thomas Jefferson spent the summer of 1804 home at Monticello trying to figure out how large the drainage system, the Mississippi River, was. Why do you think he directed Meriwether Lewis to go to the very headwaters of the Missouri River, and also directed him to go to the northernmost tributary of the Missouri? Because he was trying to determine the boundaries of the Louisiana Territory. Lieutenant Zebulon Pike, that I just mentioned, was sent along the Arkansas River, and he ends up in Colorado, modern-day Colorado, and lo and behold, he finds a mountain named Pike's Peak. What irony! I just can't believe that. But he also was sent to the headwaters of the Mississippi. And President Jefferson also sent an expedition along the Red River, Dunbar and Scott. So Jefferson was trying to determine the boundaries, and he was using the international law of discovery to do that. Because I got a little bit ahead of myself, so I get excited when I give this talk. But we'll see in a moment, one of the elements of discovery is what explains why you use the drainage systems of rivers. So Jefferson tried to calculate when the French found the mouth of the Mississippi, and of course, the United States claimed the Oregon country because we found the Columbia River first, then Meriwether Lewis and William Clark crossed the continent, continent and live at the mouth of the Columbia for several months, and Americans allegedly settle it first. Please back down to the elements. Thank you. Okay, so first discovery. You had to find it first. You had to somehow prove that to the world. Then Queen Elizabeth I in 1587 developed this other element of the Doctrine of Discovery. Just finding it wasn't good enough. You had to actually occupy these newly claimed lands within a reasonable length of time. So that's what I call my element of actual occupancy. So you had to build a fort, you had to build a settlement, you had to get some people there, and to show the world that you had not only found it first, but you now were occupying it. Next element. What did Europeans acquire? Well, Thomas Jefferson called the Doctrine of Discovery preemption. The United States' very first Congress, folks, you've probably all heard of the Trade and Intercourse Acts that the Congress enacted to limit tribal rights, Indian rights. The first Congress used the word preemption in the very first Trade and Intercourse Act, July the 22nd, 1790. So our founding fathers, those people that helped draft the Constitution and started this country, they understood this legal principle. They knew the claims that the United States were making over native peoples, and they knew it came from this ancient, crazy idea that Europeans could show up and claim the rest of the world. Usually when I give the longer version of this speech, I pick someone from the front row and I ask them, where do you live? I'm coming over today with the Bob Miller flag and the Bob Miller religious symbol, and I'm going to claim her house. What's she going to do? What's the number for 911 here? Do you have a gun? I'm going to be insane, aren't I, if I think I can show up at her house and claim it. That's what Europeans did. That's what this international law of discovery did. So when we're talking about the impact on indigenous peoples, folks, it was the colonization, it was the domination of European civilizations and religions of the rest of the world. Oh, excuse me, one more. So European title, that was this overall claim that the Europeans now own the land. In Johnson v. McIntosh, the Supreme Court says about 10 or 12 times that the United States owns the ultimate title, the sole title, the exclusive title of Indian lands, even though Indian peoples were still living on the lands, using the lands, and had been there for millennia. The United States had the chutzpah, the hubris, whatever word you want to use, to show up and claim it. So the Indian title, what was the tribe left with? Well, Johnson v. McIntosh tells us. Tribes lost the full ownership of their lands, but they still had the right to occupy and use their lands. So they could still live there, but they had lost the complete title, and the United States still owns it. Folks, you know that's still the law today, right? Tribes own what is called the beneficial title of trust lands. 56 million acres of land in the lower 48 states are owned by tribes in trust status. That means the United States is the legal owner of their lands. The tribe is the beneficial owner. As you all well know, any tribe that wants to sell, lease, or develop their land has to ask the Secretary of Interior to approve that decision. Because under the Doctrine of Discovery and Johnson v. McIntosh, the United States is deemed to be the legal owner. 11 million acres of land is owned by individual Indians in the lower 48 states in trust status due to the allotment era. Those Indian peoples are the beneficial owner of those 11 million acres. The United States is the legal owner because of the Doctrine of Discovery. So this is not just some old interesting thing that happened in history. We live this today as Indian people. So what were tribes left with? Well, we already saw what Johnson v. McIntosh said, is that tribes lost their full sovereignty. They lost their independence and self-determination. And so the Doctrine of Discovery says that tribes have only limited sovereignty, only limited commercial rights. Wow, limited sovereignty. Well, that's, of course, we know the Supreme Court of the United States says that every year in every case they decide. Contiguity, I finally got to the element about how big of an area did Europeans claim when they stuck their flag and cross in the soil. And we don't need to go back to the map because we already did that, but look at how big of a claim France allegedly had to the entire drainage system of the Mississippi River just because a Frenchman showed up at the mouth of the Mississippi in 1685 and did that charade. Look at the claim the United States made to own the entire Oregon country, all of modern-day British Columbia, all of my state, Oregon, Washington, and part of Idaho, et cetera, because an American sailed up the mouth of the Columbia River in 1792. Wow, I'm coming to your house tonight with my flag and symbol. Next. Here's elements 7 and 8 as I describe the Doctrine of Discovery. After reading Johnson v. McIntosh about 100 times, these are the 10 justifications, the 10 elements for the Doctrine of Discovery. Terra nullius, Latin words that just mean an empty land. Europeans acted as if lands that Indians were using were empty and they could claim the lands. This principle was used most vigorously in Australia, where the British government pretended not to see the Aboriginal peoples, said they don't use land, they're not here, Australia's empty, we can claim it. Australia rejected this principle, the Australian Supreme Court in the Mabo case in 1992. That's a pretty dramatic statement, and it does show that the Doctrine of Discovery can be resisted, can be fought, and changes can be made today. So that's why these efforts and what's going on at the UN Permanent Forum are important. Conquest. How does the court define conquest? Because the Illinois and Piankashaw tribes that were involved in the Johnson v. McIntosh decision had not fought a war with the U.S. They had not been conquered in a war. Now, the paper that I send you around, I think the Johnson v. McIntosh defines this word in two ways. One, yes, if a European power or the U.S. fought a war with a tribe and won, then it acquired the rights of warfare under European military law. But I think Johnson v. McIntosh defines the word conquest in a second way, what we might call a term of art. The moment Europeans showed up with their flag and their cross, they acquired all these same rights as if they had won a military battle. So I think that's how Johnson v. McIntosh describes conquest. Later American laws use this same idea. Later American laws, folks, use all of these ideas against American Indians. My last two elements, Doctrine of Discovery, civilization and Christianity. There is no question that European powers thought they were superior, thought they were bringing great benefits to native peoples around the world, and the papal bulls that Steve will talk to you about, of course, is all about this subject. The quotations I could cite you, folks, throughout American history of our presidents, our secretaries of state, people in Congress, local citizens, newspapers, they all bragged that Americans were bringing civilization and Christianity to these heathen, pagan American Indian peoples. So these 10 principles are what I think make up the Doctrine of Discovery. And so when I was writing this book in 2004 and 2005, I don't know when I started to think, well, gee, what is manifest destiny, and did it come directly from these same ideas? And that's exactly the conclusion I came to. And I used these 10 elements to analyze American history and the statements that were made by politicians and citizens and newspapers, etc., to understand what manifest destiny is and was and how it was justified. So I've totally lost track of my time. I have another hour, right, Shannon?
Yeah.
Thank you. Thanks. Sit back, relax. So it's got another hour. Let's get to the manifest destiny. What is it? I said earlier that I bet every American knows the phrase, but I bet they don't really know what it means. So next. This definition is what historians say, not me. This isn't the Bob Miller definition of manifest destiny. This is what most historians agree on. The United States has some special virtue as human beings and as institutions. You've probably all heard the phrase that we think we're this shining city on a hill. I think that was written by some New England minister in like 1640, or 60. So in 1660, we thought we were something special. And I think we still think that today, don't we? I don't want to get myself in trouble, but anyway, next point. We have a mission to remake the world in our image. Now, folks, I hope I'm not being taped because I don't want to say this on tape, but this is what we said about our Iraq War number 2, didn't we? We were going to bring democracy to the Middle East. I'll just leave my comments right there. And the third one. And we're doing it under God's direction. Now remember, this is the definition that U.S. historians give to manifest destiny. This isn't mine. So, I looked at that and I thought, well, let's analyze the Doctrine of Discovery elements with this definition of manifest destiny, and let's see what we find out. So let me take you back. The word manifest destiny was not used for the first time to anyone's knowledge until July of 1845. A New York editorial writer wrote about Texas, and that the United States owned Texas because it was our manifest destiny to own Texas, and because God wanted us to own Texas. Wow, that made me think of the Doctrine of Discovery just a little bit. 6 months later, he uses the phrase manifest destiny in regards where I live, the Oregon country. And you need to read a whole paragraph that he wrote in his editorial. He says, it is our manifest destiny to own the Oregon country. And he then used, please go back to the 10 elements. Not all of them, yeah, great, thank you. You should read just one paragraph of his editorial encompasses all 10 of these justifications. A newsman, John L. O'Sullivan, in 1845, coins this phrase manifest destiny and says the United States already owns the Oregon country. And he almost walks through these. He says, we discovered it first. Under international law, it's ours. Our people are out there occupying it. We deserve it. We're bringing Christianity and civilization to the wild savages, etc., etc., etc. He uses this. The phrase manifest destiny was repeated within a week on the floor of the House of Representatives. I believe it was on January the 7th, 1846. A congressman stated that phrase. And this idea, manifest destiny, just swept the country. Oh yes, we are God's elite. We deserve to own the whole continent. Now what I want to tell you folks is this is nothing new. This idea that Americans were special, yes, started in 1640. This idea that Americans were going to sweep the continent started with George Washington, started with Thomas Jefferson, all the presidents and Secretary of States long before John L. O'Sullivan writes the word manifest destiny. In fact, let me tell you that our 13 original colonies, 7 of them are called landed colonies because the charter that the kings of England gave them granted them the land in North America clear to the South Sea. Well, that was their title of the Pacific Ocean at that time. Now, they didn't know if the Atlantic to the Pacific was 10 miles or 3,000 miles. But still, the kings of England were granting those kind of ownership to the colonies. And they continued to claim those and only gave them up as late as 1802. 5 minutes. I thought you said I had... Okay, well, 5 minutes. I got to talk fast. The main two things... Okay, so we claimed the whole United States. You know what General George Washington said in 1783? He was only a general then, and he was asked by the Congress, how should we deal with the native peoples? Should we fight a war with them, or what should we do? General Washington makes a very famous statement, folks, that I think was American federal Indian policy until probably 1970. George Washington coined a phrase, the savage as the wolf. And you can read his letter today. It's online. He writes, James Duane, one of the senators, and here's his recommendation. We don't have to fight Indian people, he said, because we will get their lands as soon as we want and when we are ready to get them. He says, and I'm paraphrasing here, but he goes, what happens to the animals of the forest as we advance our frontier? He says, they disappear, don't they? Then he says, it is the same with the savage, quote, the savage as the wolf, close quote. So what Washington was saying is that Indian people will disappear in front of us like the snow disappears before the sun. And that idea was repeated throughout American history, and literally, I believe, what was the termination era about, folks, in the 1950s? Indians are gone, they're disappearing, they're on their way out. But now, in this self-determination era, now in this era where tribes are exercising their authority and their sovereignty, the United States is going, wow, what happened? But that's what George Washington foretold. Do you know what Thomas Jefferson said, President Jefferson? He said that we will drive the Indians along with the beasts of the forest into the Rocky Mountains. So he had the same idea that this continent was for Americans and indigenous peoples were to be gotten rid of. Gosh, you all know what the removal era of federal Indian policy is. Thomas Jefferson was the architect of it. He was writing about it in private letters in 1803, long before Andrew Jackson was president and long before the Removal Act was enacted in 1830. Okay, well, I have too much to say, but this idea, oh, well, I got to mention this. Do you know what our founding fathers' favorite Bible scripture was? I have read this. You thought, how'd this guy get on a Bible? Genesis 1:28 was the favorite scripture of the English colonists and our founding fathers. And in case you don't remember what Genesis 1:28 says, that's the verse that says something about God tells man to fill the earth, multiply, and subdue it. And this subduing of the earth was very much what the colonists were into, and they wanted the possession of it and to use it to the best and highest use, of course. Okay, I need to wrap up here very quickly. I want to emphasize President James K. Polk. I literally at breakfast this morning, the people at the next table were talking about James K. Polk. And you go, why is he talking about James K. Polk? Back to the map, please. James K. Polk runs for president as the Democratic representative in 1844. The Democratic Party platform in 1844 said, we are going to grab Texas. We're going to grab the Oregon country because God meant us to have it and it's ours. James K. Polk runs on the campaign slogan, folks. How many of you remember this? 54-40 or fight. What the heck was he talking about when he said 54-40 or fight? You know you don't run for president with a slogan no one knows, right? So today we forgot it. But everyone alive in 1844 knew what that meant. He wouldn't have used the slogan. 54-40 or fight, folks, means that James K. Polk was using the Doctrine of Discovery, the international law principle of how large the Oregon country was and what claim the United States had to the Oregon country, because we found it first, then Lewis and Clark went there, and then John Jacob Astor builds Astoria and occupies it. Do you know where the 54th degree of parallel is today? It's the very tip of Alaska. We were claiming all of British Columbia and all that blue area because it's the drainage system of the Columbia River. So in 1844, when Polk runs for president, the people know what he's talking about. International law, these principles of how Euro-Americans claimed new territories just by showing up with their flag, or as Meriwether Lewis did with his branding iron. So please go to the last slide. I was going to read you a couple quotes from various, well, I've got to cite you this one. Henry Clay, who was Secretary of State of the United States in 1825, he was talking about American expansion. And he said, things aren't going to turn out so well for Indian people. Well, let's not try to, well, now can I find it? Shannon, you got me, hurry, you got me, hurry. James Clay Polk said, it is, and here's a quote, impossible to civilize Indians. ... they were destined to extinction, period, close quote. So that's what the United States Secretary of State thought in 1825, and that's what he said and wrote. The United States, American people have the right to all of this, and Native people are going to disappear. Gee, that's what George Washington said in 1783, isn't it? So manifest destiny was not a new idea, folks. It was just a repetition of these elements of the Doctrine of Discovery, this idea of European and Christian superiority and right to the entire world. And so I'll just end very quickly with this, because this is the Oregon country. How did the Oregon country become part of the United States? An American found it first, allegedly. First discovery. Robert Gray's boat, that was the name of his ship, folks, so he named the Columbia River after his ship to show the United States' claim to the area. President Jefferson then sends Lewis and Clark across the continent and says, build your fort and live at the mouth of the Columbia River. Establish an American claim. And then John Jacob Astor, that American fur trader, tells President Jefferson, I'm thinking of building a trading post on the Pacific Ocean. Oh, maybe at the mouth of the Columbia River. So I don't know how many of you know my state of Oregon, but Astoria is still on the Oregon coast at the very mouth of the Columbia River. And Thomas Jefferson was delighted that an American company was going to build a permanent occupation there. Remember, that's one of the elements of the Doctrine of Discovery. So give me 30 seconds. What's the impact of the Doctrine of Discovery today? Every federal principle that you're aware of comes directly from the Doctrine of Discovery. What are the three fundamental principles of federal Indian law? Congress has plenary power over tribes and can do anything it wants to them, good or bad. Where does that come from? The Doctrine of Discovery, the power that Europeans claimed and the limited authority of tribes. Second, the trust responsibility. Well, you've all heard that. Why does the United States assume this trust responsibility over tribes? Well, partially because the United States claims this overarching power over Indians and indigenous peoples. And with overarching power comes a trust responsibility. And third, you all know the third fundamental principle, that tribal governments are sovereigns, but they're diminished sovereigns. Where does that come from? The 10 elements of the Doctrine of Discovery. So I wish I had another hour to talk to you, but I'm done. Thank you for your attention. The impact of the Doctrine of Discovery. Thank you.